Get my case dismissed. I can't tell you how many times I've been asked that question. Every client that comes through the door says, "Can you get my case dismissed?" They offer insane amount of money to get the case dismissed. It goes something like this. You know what? I never thought I would be sitting in a criminal defense attorney's office. I've lived a reputable life, an honorable life. I have no idea why I got arrested. I suffered the humiliation of getting arrested, getting fingerprinted, having my mugshot taken. It was published online. What's going on? I can't be living with this nightmare. This is crazy. It needs to be done. It needs to be over. Can you get my case dismissed? Or a parent comes and says, "Look, my son's a good kid. I don't know what happened at college. I don't know what went on at that party, but I know he's a good kid. I make a lot of money. Whatever it takes, I'll pay you. Add as many zeros as you want to the check. Just get it dismissed. I need a guarantee from you that you're going to get it dismissed." Okay, now, any attorney, here's a big warning. Here's a very, very important tip. Any attorney who makes a guarantee about the outcome of your case, who tells you, "Look, I can guarantee a result," run in the other direction. Get out of that attorney's office. That is unethical. And if you think about it, it makes no sense. I wasn't there when you got arrested. I didn't witness what happened. The prosecutor wasn't there. He or she didn't witness what happened. The judge wasn't there. There's an entire process that goes on before we can look at the strengths and weaknesses of your case. So if on an initial consultation an attorney is making that kind of guarantee, that's a red flag. Something is up. To answer the question, yes, it is possible to get a criminal case dismissed. It's possible. I'm going to explain it. It's a little complicated. I'm going to simplify it. I'm going to use really simple examples just to give you the idea, okay? Just to give you the idea of how a criminal defense attorney gets a case dismissed. We're going to get into it. All right, first thing you need to know is the prosecutor. For those of you who don't know, a prosecutor is an attorney just like me, but they represent the people, the state of New Jersey. So when you commit a crime, when you commit aggravated assault, you punch somebody in the nose. Yes, there is a victim, but the person representing that victim is the prosecutor. The victim, in a bigger sense, is the state of New Jersey. Crimes are committed against the state. Now, the case is the state's case. That means the prosecutor has to prove that you committed aggravated assault against the victim. And the standard of proof, which we've heard in movies and TV shows, is beyond a reasonable doubt. Everybody's familiar with that. So, we start with that very basic concept. The prosecutor has a case, they have to prove it beyond a reasonable doubt. So the first thing we do, once we meet with you and we hear your side of the story, we write everything down, we make an assessment about what you're telling us, and we start thinking about legal defenses, okay? We listen very closely, and we understand why you punched somebody, why you broke their nose. And we learn through our consultation, through our initial meeting, that you were acting in self-defense. So we have that tucked away. We know up here that it's self-defense, affirmative defense that you may have. Now, once we get into the case, we start to get all of the evidence. In legal terms, it's called discovery. It's just a fancy word, but it means evidence. The police who arrested you, they will gather witness statements, they will gather surveillance evidence if it happened in a bar. We will get that at some point in time. Once we get it, we review it. And if it's consistent with what you told us, now We approach the prosecutor in a professional, respectable, courteous manner. It's not like the movies where the defense attorney and the prosecutor are at each other's throat. We don't go in there pounding our fist and yelling and insulting. No, it's a very professional setting. And we say, look, Mr. or Mrs. Prosecutor, I went through the evidence. I don't know if you've had time to go through it, but I don't think you can prove your case beyond a reasonable doubt. My client did not commit aggravated assault. My client was defending himself. My client did not provoke this fight. My client had no choice. Prosecutor will say, thank you for that. Give me some time to review the evidence. I want to speak to the officer. I want to speak to the victim. I want to see the surveillance video myself. After 2 or 3 weeks, we meet again, and the prosecutor says, you know what? This is a kind of case I do not believe that I can prosecute. I do not believe that I can successfully prove beyond a reasonable doubt that your client was the aggressor and committed aggravated assault. I recognize from the evidence, from the discovery, that there is an affirmative defense. And with that said, I've looked at your client's record. He has a clean record, never been in trouble before. That's very important. Let's do this. Let's agree to dismiss these criminal charges. But I never want to see your client ever again in my court. That's a very simple, basic example, but that's how it works. We meet with you, you tell us your version of the story, we get the evidence, we examine everything. It takes 2 or 3 months. We meet with the prosecutor, we exchange points of view, and the prosecutor at some point agrees that he or she cannot prove their case beyond a reasonable doubt. Now, that's a way to dismiss involving the prosecutor's agreement. That's a way to get the case dismissed involving the prosecutor. But let's use the same example where you're charged with aggravated assault, punching somebody in the face, and the only evidence that the prosecutor, the state, the police have is your statement. In other words, no witnesses, even the victim doesn't remember who punched him in the nose. There's no surveillance. The only piece of evidence is your statement. Now, when police approach people, they can approach people on the street, they can approach people in their car, they can approach people in their home. I made it very simple. Let's say you're at home and you receive a phone call and it's a detective and he says, I want to talk to you. Can you come down to the police station? Well, what is this about? No, part of my investigation, your name came up. I want you to come to the police station. You don't call us. You don't call a defense attorney. You think to yourself, maybe this has something to do with what happened last night in the bar. I don't know, but I want to go and explain what happened. So you go down to the police station voluntarily. Once you get there, you're having second thoughts. I don't know. I don't think I should be here. Something's up. The detective welcomes you, takes you to the interrogation room, and you ask the detective, do I have to be here or am I free to leave? And the detective says, no, you're under arrest. For what? Well, we think you had something to do with the victim's nose getting broken. And you repeat, Mr. Detective, do I have to be here or can I leave? Am I free to leave? No, I just told you you're under arrest. You're going to give me a statement. I'm using this example because it happens a lot. And I'm going to make it really obvious. The detective proceeds to question you. And you ask the detective, hey, when I was in college, I learned something about Miranda. Don't I get my Miranda warning? And the detective says, no, you're not going to get a Miranda warning. You're going to tell me everything that happened. And you proceed to give a statement. Now, I made it very obvious, but I really want to get the point across. You gave a statement in violation of your constitutional Miranda rights, your constitutional right to remain silent, your constitutional right against self-incrimination. I made it very obvious, okay? You did go down there voluntarily. Once you got there, you had a change of heart. The detective brings you in, puts you under arrest. You're not free to leave, does not read you your Miranda rights, continues to interrogate you. You tell him, yeah, I punched the guy in the face. He was annoying me. He was hitting on my girlfriend. Whatever your explanation is, and he arrests you and charges you with aggravated assault. Now, we get all of that evidence, okay? You tell us what happens. We compare it to the police report. We get the interrogation room video, and we realize everything you told us is true. You never received your Miranda warning. We're not trying to persuade the prosecutor that they cannot prove the case beyond a reasonable doubt because they have a confession. So how do we get the charge dismissed? How do we get these criminal charges dismissed? We file a motion to suppress, to keep out the statement. The only piece of evidence they have against you is the statement. So we file that motion to suppress. It's a legal document. Again, we're not trying to persuade the prosecutor. We're showing the judge, hey, my client's constitutional rights were violated. You cannot allow this piece of evidence to get in. We go to court. We have a hearing. The judge, I'm keeping it very simple. The judge agrees with us. The judge makes a ruling. The judge says, I've heard all of the evidence. I've listened to all of the witnesses. And it is my decision, based on the law, that this statement, this confession, was given in violation of the defendant's Miranda warnings. The statement gets suppressed. Now what happens now? They don't have a case, right? There's no case. There's no evidence. The statement is out, no witnesses, no surveillance. The victim doesn't remember who hit him. Now the prosecutor says, well, without that statement, I can't proceed. And the charges get dismissed. I'm going to take a very common example, a drug case. Let's say the police searched your home without a warrant and they found drugs in your home. Very simple, right? You know this one. For the police, state actors, law enforcement agency to search your home, they need a warrant. The Constitution says police need a warrant to search your home. Let's say the police knocked on your door. Can we come in? No, you can't. I read a lot of legal stuff. I have a expectation of privacy. I have a Fourth Amendment right to be free from police coming through my house. And the police say, you know what? Are you refusing my entry? And you say, yeah. If you think it's rude, I really don't care. You're not allowed inside my house. And the police say, I don't care. I'm coming in. They don't have consent. They don't have a warrant. They go through your house. They search everything. And they find a little bit of drugs. I'm keeping it really simple. Well, guess what? We're going to file a motion to suppress. That means we tell the judge, look, our client's constitutional rights were violated. The only way they found these drugs was by violating the constitutional right. They searched their home. Judge, this is illegal. Judge tells us, you know what? You're absolutely right. I'm going to suppress this evidence, which means suppression keeps it out. Without the drugs, there's no case. Therefore, case dismissed. Now, we went through two very simple methods, two very basic ways that you can get your criminal charges dismissed. By no means, in the spirit of honesty, that's the only way we know how to work, is honestly. In the spirit of honesty, this is not easy stuff. It happens. We've gotten cases dismissed. It's possible, but it's not easy. It gets very complicated. It gets very technical. It's a long process. Sometimes it takes 3, 4, 5, 6 months, a year to get a case dismissed. So by no means I don't want you to leave this video thinking, oh my God, I'm going to hire this guy. It's very easy. It's not easy. However, I want to close with this. Regardless of who you decide to work with, I wish you the very best. I hope you get an attorney. If it's not us, I would love for it to be us. Come meet with us. We offer free consultations. We don't rush people. You can sit with us for 30 minutes, an hour, 90 minutes. I don't care. Tell us your side of the story. It's free. It's like a $500 value. Come meet with us. Got nothing to lose. But if you don't meet with us and you choose to work with someone else, I wish you the very best. Lastly, I like to close all of my videos with God bless you.